Welcome to the International Business and Law Academy. My name is Ann, and today I will be presenting about private international law of the international legal system. I will be using the case of Barcelona Traction Light and Power Company Limited in order to discuss and understand about the nature and function of international law, the rights and obligation of private parties. Facts. Barcelona Traction Light and Power Company was a holding company that formed a number of subsidiaries in Spain to produce and distribute electric power. Although the company was incorporated in Canada and maintained its registered office there, about 88% of its shareholders were Belgian nationals. Barcelona Traction issued several series of bonds payable in sterling. However, it was later prevented from paying interest on the debts when Spanish exchange control authorities blocked the transfer of necessary foreign currency. After several Spanish bondholders demanded that the corporation be declared bankrupt because of its failure to pay interest on the bonds, a Spanish court ordered the seizure of corporate assets, including the shares that were held outside of Spain. Later, a Spanish court authorized the issuance of new shares for the subsidiaries. They were purchased by a Spanish corporation, which then assumed complete control of Barcelona Traction electric power operation in Spain. Belgium, on behalf of the Belgian shareholders, filed a claim against Spain in the Court of Justice. Spain argued that Belgium lacked standing to bring an action against it. So the issue to discuss is, did Belgium have standing to bring this action to protect the Belgian shareholders? I invite all of you to discuss this case together. You can talk specifically about the case of dispute, and at the same time, you can give a justification for applied theory of this case. Please start. Ruby?
I think I'm going to give a justification for the applied theory in this case first. Because Barcelona Traction Light and Power Company was a holding company that formed a number of subsidiaries in Spain to produce and distribute electric power, and about 88% of its shareholders were Belgian nationals. I think this is a multinational company investing in electricity sector in which attracts capital across many countries.
I completely agree with Ruby. This is a multinational corporations. So when cooperatives invest in a country, they must be ensured that the payment problem on the international market or the capital recovery must be guaranteed. The source of payment is foreign exchange. So in this case, Barcelona Tractions issued several series of bonds payable in sterlings. However, it was later prevented from paying interest on these debts when the Spanish exchange control authorities blocked the transfer of necessary foreign currency. This is too great of a risk for investors.
Indeed, this is like the nationalization of corporate assets, because it was noted that a Spanish court ordered to seizure of corporate assets, including the shares that were held outside of Spain. And later, a Spanish court authorized the issuance of new shares for the subsidiaries. They were purchased by a Spanish corporation, which then assumed complete control over Barcelona Traction electric power operation in Spain.
I think that the Belgian government cannot act on the behalf of the shareholders of the company who are Belgian citizens to shoot that the Spanish government, because that the company is headquartered in Canada, so registered legal entity in Canada and is not in Belgium.
I think that this case is not a territorial dispute between sovereign countries. It's just an investment dispute between the investor and improper management of the host country. So according to the applicable law, then international justice courts do not adjust case like this.
Thank you all so much for your discussion. Before we move into the answer of the case study, let's review the theories that is relevant to the case study. Ruby, start us off.
So I'm going to talk about the public and private international laws. Public international laws deals with the rights and obligations of sovereign states, whereas private international law regulates the activities of individuals and corporations.
Alright, so the International Court of Justice was designed to resolve legal disputes between sovereign states. Private parties must turn to national court or international arbitrary panels to protect their legal rights.
I also want to talk about the principle of diplomatic protection, because although the International Court of Justice only deals with territorial disputes of sovereign states, countries sometimes still use their diplomatic rights to question the International Justice Court's resolution of investment disputes that have great influence on the nation.
The United Nations of International Court of Justice, it composed of the court and frequently called the World Court. Headquarters in The Hague, composed of 15 judges who are served in 9 years term by formers of National Court Justice or ex-legal practitioners or ex-law professors.
The International Court of Justice, including Chamber of Summary Procedures, is composed of presidents, vice presidents of the court, as well as 3 other judges who are designated each year. Special chambers that can specialize in hearing particular type of case. Ad hoc chambers, when a legal conflict arises, the disputants can call for the creation of an ad hoc chamber.
Again, thank you all so much for discussing the theories. And now let's go back and answer the case study. So the decision here is no. Generally, modern corporation laws are grounded on a firm distinction between the separate entity of the corporation and that of the shareholder, each with a distinct set of rights. The separation of property rights as between corporations and shareholders is an important manifestation of this distinction. The mere fact that damage is sustained by both corporations and shareholder does not imply that both are entitled to a claim of compensation. Thus, whenever a shareholder's interests are harmed by an act done to the corporation, it is to the latter that he or she must look to institute appropriate action. Shareholder and company, although 2 separate entities, may have suffered from the same wrong. It is only the corporate entity whose legal rights have been infringed. This traditional rule attributes the right of diplomatic protection of a corporate entity to the nation under the laws of which it is incorporated and in whose territory it has a registered office. Thank you so much, and thank you to the International Business and Law Academy, and especially Dr. Sung.